A woman maintains different kind of relationship in her life, being a mother, being a daughter, being a sister, being a friend. But in India we have this popular perception that a woman is incomplete without motherhood. But I want to ask you that motherhood is a choice or compulsion. Hello everyone, welcome to the new series of Drishti IS. I am Ritu and today we are going to discuss an important topic, which is abortion law in India, and this topic is important from GS2 perspective, and it can also come in your ethics paper and also in your essay paper. So moving to the points of discussion part. So first of all, we are going to discuss the news and then debates around the abortion laws in India, and then what are the present abortion law we have in this country, and after that we are going to discuss practice question for prelims and mains. So moving to the news part. So recently Supreme Court had allowed to terminate 26-week pregnancy of a married woman because there was a petitioner in the Supreme Court and she was a married woman carrying 2 children already. So she went to the Supreme Court and she said that she don't want to carry the third child because of the financial problem, economical problem, mental problem and physical problem. So on the ground of all these problems and considering, the Supreme Court had allowed that women to terminate its pregnancy. However, this decision has created much furore in the Indian media and also in the judicial system, and there were 2 women judges who were divided on this issue. So we have 2 women judges, Justice B.V. Nagaratna and Justice Hema Kohli. So what is the opinion of Justice B.V. Nagaratna? So Justice B.V. Nagaratna says that she does not find any problem with the current Supreme Court ruling. On the other hand, Justice Hema Kohli said that her judicial conscience is not allowing the women to terminate its pregnancy. So this was the debate between 2 women judges. So that reminds us that what are the present abortion law in India and what changes it required further. So moving to the next slide is about what are the historical perspective of abortion law in India. So did it started from 1947 itself? So it has not started and it had not implemented since 1947. Till 1960s, we don't have any proper abortion law in India. And if any woman does abortion kind of thing, she or he is punishable under the Indian Penal Code 312. And there was lots of debate around 1960s that why women have not this kind of right, because reproduction is a right and women should have reproductory choice. So after that much debates and much demand, the government of India had formulated a committee whose name is Shanti Lal Shah Committee, and Shanti Lal Shah committee had given few kind of recommendation, and on the basis of that recommendation that women reproductive choices must be respected and they should also have this abortion rights like the other Western countries. And on that basis, medical termination bill was introduced in the Indian Parliament and it got passed in 1971 and it became an act and it was applied to whole of the India except Jammu and Kashmir. We are talking about that time, not today's time. So this is the historical perspective of India's abortion law. Coming to the Medical Termination of Pregnancy Act 1971. So this act allows abortion in 2 stages. So the first stage requires the abortion up to 12 weeks, and here the single doctor opinion is required. But when you have to abort after 12 to 20 weeks, you need to consult 2 doctors, and that too with a certain condition. So what are the conditions? That pregnancy would involve a risk of the life of the pregnant women, and also it can produce grave injury to the women and the physical and mental harm to the women and the child. So on the basis of all these criteria, this thing is applied. So this was not an easy process. So by seeing all these things, there was a recent amendments in 2021 onto this bill. And what are the amendments we have? So this has amendment that earlier it was 12 weeks and only 1 doctor advice is required, but now the 12 week has extended to the 20 weeks, and in case of rare circumstances 20 to 24 weeks the opinion of 2 doctors are required, and they fall under this category. And after 24 weeks there is a 3B rules prescribed in the act, and what this 3B rule says that under rare circumstances a woman, whether it's married or unmarried, they had right to abort the child. And what are the rare circumstances we have? The survivors of the sexual assault have right to abort, and then minors, and the change of marital status, whether it's widowhood and the divorce, and then women with physical disabilities, and mentally ill women and mental retardation. So under these prescription or under these criteria, the 3B rule is applied and they are allowed to terminate their pregnancy after 24 weeks. So these are the basic thing about the 2021 MTP Act. So moving to the next slide, which is practice question for prelims. So consider the following statement regarding medical termination of pregnancy 2021, because this is the recent one. So the first statement is unmarried women are also covered. So you need to find out that unmarried women are part of medical termination pregnancy 2021 or not, or whether they were part of 1971 or not. And then your second statement is till 20 weeks opinion of only one doctor is required. So we had already studied about that till how much week, how many doctors opinion is required, and here they are asking the correct statement. So you have to answer this in the comment section. So moving to the mains part. So the mains question is, what are the issues related to medical termination of pregnancy act 2021 discussed with regions? Here they had given this 2021. It means they had already specified the date. So first of all, you have to give introduction of MTP Act 2021, and you have to also give the brief background of 1971 and also the 1960s arena where women have no right and no law in India persists towards the abortion thing. So you have to give this brief background that how women have got this kind of right, and it is a recent development. And then they are asking that what are the issues related to it. So in MTP 2021, we can see that unmarried women are also allowed to terminate their pregnancy. But in case of a rule, there is a rule which had just covered the what you can say, the widowhood and divorcee women. It means that they had specifically written here that change of marital status. So there they have not covered the unmarried women. So this is one of the loophole of this MTP 2021. And then we need to also work on the perception, because if any unmarried woman goes to the medical houses or any hospital, she has to go through lots of problem, lots of judgment, and medical practitioner behave differently with that women. So there is no particular law for these kind of things. On the other hand, the men's consent has not clearly designated in this kind of thing. So these are the issues related to this MTP 2021. And we have this kind of laws in India, but there is a faulty implementation in this country, and still women have no right on their reproduction. So these things must be regulated, and women should have right on their reproduction. They should have, and they are free to make their reproductory choices. So these are the basic things about the 2021 MTP Act. I hope you like this lecture. If you have any queries related to this lecture, kindly ask in the comment section.